I will now call 124-724, State of Kansas versus Brandon Keith Jordan.
May it please the court, James Ladd, the Appellate Defender's Office, representing Brandon Jordan. We're here today on a felony murder charge with the inherently dangerous felony being a fleeing and eluding, which ended in a deadly car crash. And to jump straight into issue one, the first issue is alternative means. And I would like to start by saying that we're here on an alternative means issue because the state chose to charge this case with numerous and/ors in its charging document, listing out multiple alternatives of how the defendant could commit a fleeing and eluding. Then at trial, the state requested numerous and/ors in the instruction, including alternative means for fleeing and eluding. And after the state requested that, the district judge even said, I think sometimes it's too confusing to have all those choices. And we went ahead with it. So that's why we're here now with this issue. And as this court has said in Davis, subsections B1 and B2 we already know are alternative means. When you insert those alternative means into felony murder, we now have alternative means for felony murder. And as we go through all the and/ors, we come to the possibility that the jury could have convicted of fleeing and eluding for the and/or of identity theft. And then when we turn to the identity theft instruction, we find that once that identity theft instruction is inserted into fleeing and eluding, there is a component of that of the identity theft instruction that as a matter of law could not have occurred while fleeing and eluding. And that's Brandon Jordan lying to the police officers about who he was. That had happened after the crash when he was no longer driving a motor vehicle and he was no longer committing a fleeing and eluding.
I understand your argument. What we have to decide to get to your final conclusion is that under B2, listing more than one felony for which a defendant was attempting to elude capture creates an alternative means issue, not options within a means.
That's correct. And so my best case for that is the Sasser case, which I cited in my reply brief, which specifically says that alternative means isn't just about insufficient evidence, it's about jury unanimity. And it goes on to talk about how the instructions can cause all these issues with alternative means. So once I raise the issue of alternative means, we have to, in my opinion, based on the case law, that's the world we have to live in. So now when we look to B2, which is the alternative means of attempting to elude capture for forgery and/or identity theft, in order to be sure that that entire alternative means is sufficient, that there's sufficient evidence to support forgery and/or identity theft, we have to show the whole thing. It's not sufficient just to show that the forgery was sufficient, because based on the instructions and based on the Sasser case, we can't know that for sure.
Start though, in alternative means by looking at what are the material elements of the crime. And the fleeing and eluding statute itself only says commission of a felony. It then references you to a definitional, basically list of what those felonies can be. And then that in turn shoots you to another statute to define what those, or a multitude of statutes to tell you what the elements of those are. And in Brown, we said basically anything that is a definition or a description is an option within a means, not an alternative means. So what's your argument as to why we wouldn't apply that holding from Brown here? When you don't have that, those the second cousin elements in the fleeing and eluding statute itself.
Sure. And just so I understand your question, are we talking about subsection B2 about the forgery and identity theft, why those aren't just options in a means?
Right.
Sure. And my best argument for that is that we are now in the world of alternative means, like I said. We do
Right,
not,
so maybe we would start and breaking this down. There's nothing in that subsection that refers to those elements, is there?
to forgery and identity theft.
Right,
No, it just says any felony. You're
it says any felony. So why isn't that almost a hard stop to say that is not an element of the crime of fleeing and eluding? You just have to commit a felony. That's the element of fleeing and eluding. And then the legislature has defined what felonies qualify, but that's a description does that fall within the description holdings of Brown, where we say no, anything that's a description of a element is an an option within a means.
So basically you want me to tell you why? Because the state proved forgery. That's not sufficient. Is that correct?
No, I want to
I'm sorry.
say why under Brown, this is not to get over to a felony, the specific felony. Why that is not a description as opposed to an element of fleeing and eluding.
I understand. And my answer would be, it might be a description. And the reason why that doesn't matter in this case is the Sasser case, which says that the jury instructions themselves can insert the lack of unanimity that we're worried about.
We're not worried about lack of unanimity if it's options within a means. That's the whole point, isn't it? Is that if it's options within a means, we're not worried about unanimity.
I agree. And I would go back to saying that we are in the world of alternative means. And the only way we can know for sure that the entire alternative means of B2, which is forgery and or identity theft, is for the state to have proven both. There has to be substantial evidence to prove both.
That answer is contrary to your answer to my question, that we're talking about a description or a definition, because under Brown, that's an option within a means, not an alternative means.
Right. And my best argument on that is just that it doesn't matter because of the way the instructions are worded. And again, the Sasser case is my best argument on that the instructions can.
Would you agree that this jury was unanimous in its finding that that your client made a felony? I mean, it was, right? It was unanimous on that question. It might not have been unanimous on the question of which felony, but it was unanimous on the question that your client committed a felony.
Because we have separate verdict forms, knowing that so we know for sure that they found he committed a felony.
No,
they're
because the
separate.
instructions charged with forgery, they were instructed on forgery and they convicted on forgery, for example. Or they were instructed on identity theft and convicted on identity theft. I
Right.
think. Sorry, I didn't mean to interrupt.
Or just because they found that the fleeing and eluding happened. That's the element of fleeing and eluding, and they found the defendant guilty.
Right, but they could have found him guilty under their subsection B1 because of all the and ors. And so that wouldn't prove the alternative means of subsection B2. And
You
so
don't dispute that there was sufficient evidence of B1.
I do not dispute that. And I also do not dispute that there was sufficient evidence of forgery. We are trying to burrow all the way through and try to get to that identity theft and trying to say that the entire alternative means of B2, because of the jury instructions in the Sasser case, they have to show that substantial competent evidence supports each one. And because of the instructions, my argument is that forgery and identity theft makes up the entire alternative means.
Should we look at this as an instructional error issue rather than alternative means? Is that the better lens, since it seems that you're suggesting that all of this arises based on the way the jury was particularly instructed here?
Sure, there is an instructional error too. There's probably a instructional error with factual appropriateness, but it wasn't objected to, and then I'd be under the clear error standard. So that's why I purposely raised this issue under alternative means. And because that's our best chance at getting reversal of the charges we need reversed for my client.
Claim that there's any evidence at all that would support the theft alternative mean that you're talking.
So there is
One
evidence.
that you say that there's no, that you're saying there's no evidence to support one path. And
Correct.
so now we're back in that fun discussion we always have about harmless error and all that. Because there's no evidence to support it.
Right, and so I would just say that, so that's why this is why I'm raising this as an alternative means issue. To try to get away from harmless error. Because if we get to harmless error, then I can't concede it, but I certainly admit we have a hard road ahead of us. I would note, though, that in closing, the state did say to the jury, they said, ladies and gentlemen, the state has presented either each or elements. So if you find one, that's enough. So that's at volume 13, page 634, 635. So the state did tell the jury that they could pick just one of those and/ors. They didn't say they had to agree on all of them, and they didn't elect just one for them to agree on. Then if there's no questions for issue 1, I'll move on to issue 2 quickly. Issue 2 is that the state, Shawnee County in particular, is not bringing these indictments in the correct way. Is that the way the statutes are written is an indictment can only be used to start a prosecution. And so there's no law authorizing these indictments to be substituted in the middle. And we cite the statutes that talk about bringing the indictment in the first place. And they talk about, it says a prosecution shall be deemed to have begun. Well, that's not what happened here. They filed the indictment in the middle after it had already begun by complaint. And my argument is that because we get jurisdiction from the statutes of Kansas, and the statutes specifically tell us how to bring cases in Kansas, when you don't bring a case the right way, there is no jurisdiction for that court to hear that case. I'd also direct this court to the statute that's cited in the indictments, that the statute 22-2303, which says when an indictment is returned as provided by 22-3011. When you go to 22-3011, subsection C, it says indictments found by the grand jury shall be presented by its presiding juror in the jury's presence to the court and shall be filed and remain records of the court. So my reading of that subsection is, because the state talks about in its brief that we just dismiss this and then bring in the indictment, and rather than doing the substitution thing. And they could probably do that, but they would have to dismiss the complaint based on my reading of these statutes before they even convene the grand jury. Because when you combine these two statutes together, I think the most plain reading is once that grand jury returns an indictment, you have to file that indictment, and you have to file that in a new case, because it says an indictment, a prosecution shall be deemed to have begun once that indictment is filed. So that's my argument on that. And if there's no questions, I would just ask this court to reverse based on my briefs, please.
Thank you.
Good morning. May it please the court. Again, my name is Jody Litvin, and I'm a deputy district attorney who represents the state in this matter. I think this court has generally hit on the points that I wanted to make as far as issue 1, looking at jury unanimity as the problem or the complaint here for the alternative means. We have separate jury verdicts for the forgery and the reckless driving and the identity theft. So I don't think the jury unanimity issue is a problem here, and that this court can have confidence that the jury did unanimously find him guilty of
By
forgery.
making that argument, are you conceding that the statute presents alternative means?
You know, I don't think I thought about that in the brief. But I don't want to concede that, no, but I don't know that I made the argument that it's not, but I do agree that under Brown, I think it can be any felony is the means. And as far, I didn't have any other comments. I mean, unless this court has questions on that issue.
Well, if it is alternative means, there were multiple acts that were identified in the instructions for identity theft, right?
Correct.
Okay,
There
and
were multiple intents to
Well-
defraud multiple.
correct.
Yeah.
Yes. And one of those could not, I don't know if you say as a matter of law or fact, but could not support a fleeing and eluding under B2. Would you agree with that?
I don't think,
Because that identity theft happened after the fleeing and eluding crime was completed.
correct. I don't think that was occurring. Yeah. I mean, he gave the fake name to law enforcement after the crash.
So does that not create a unanimity issue if multiple felonies identifying multiple felonies under B2 creates an alternative means issue?
I mean, it creates a jury unanimity issue, but I think you can find that harmless because we have other jury verdicts that say that the jury unanimously found on forgery and on other felonies. So like.
But that's
as we-
not the case. I mean, we don't know that. I think what Justice Wells is driving at is we don't know that the identity theft conviction was used by the jury to support the fleeing and eluding.
The way that the flee and eluding instruction was written, yeah, it didn't specifically parse out each one, correct? But if we have another felony that they unanimously found a legally adequate felony, adequate theory, then what's the harm in knowing that the jury did unanimously find him guilty of a felony? I mean, I guess that just goes to my harmlessness as to why this should be more of an instructional issue, not a sufficiency issue where it's bam, gets reversed. There wasn't sufficient evidence for that. We have to start over when we do have a jury verdict that says we did find him guilty unanimously of this felony. So I think it should be treated more like an instructional error. And as far as the second issue, the state, as we argued in the brief, says that there's no problem here in the way that the state substituted the indictment for the complaint. I think it's a matter of judicial economy. I don't think a grand jury is, we don't do that every week or every day. So we file the complaint first, and then when the grand jury is convened, they issue their indictments and we file them. I don't think there's any prejudice to the defendant here, and I certainly don't think there was a lack of subject matter jurisdiction for the court in the way that this was done.
Why isn't there some prejudice to the defendant to do it this way? Maybe not legal prejudice, but just the fact that you have to sit under the shadow. I mean, you have to be, a case has to be initiated against you under the complaint procedure, but then you lose your preliminary hearing opportunity. And is that why the state is doing this?
To lose a preliminary
Well,
hearing?
in other words, you're filing a case with a complaint. And then sometime after that, you are presenting the evidence to the grand jury to get an
Right.
indictment.
Right.
Why is that happening?
I mean, well, one, I think there's a charging deadline for when if you were arrested, and there's a charging deadline to have to get charges on file. I think practically speaking, there's a timeline for when the state has to file charges after an initial arrest. So we filed a complaint because the grand jury, like I said, isn't convened daily. And then when the grand jury is in session and they file their indictment and they find what they find, the state proceeds on that. And it's just giving notice of the charges twice, essentially. So I guess I don't see the prejudice.
Well,
And-
there are real practical implications and effects of being charged with a crime.
Yes,
So it's not just notice.
no, I mean, it's not, but it's allowed under our grand jury statutes. I mean, I don't know that it does take the place of a preliminary hearing, which is authorized by the grand jury. Defense may not like it, may not like to be, that they don't get that process, but there's nothing, it's set out by statute as something the state can do.
Yes, I agree with that. Is there any sort of bigger principle of justice or equity that would suggest that the state ought to be held to its initial election of how to proceed with the case?
I don't know that I don't know that the states has to be, there's anything in the statute that says that we're bound by the way that we initially do that. Because it says complaint, indictment, or information. So I guess my answer would be no. And I don't think I have any other presentation. I could hit on the prosecutorial error since I have time. Our position is that the state did not properly comment that this witness told the truth. If you look at in context and if you look at the case law, this is certainly something that this court has said prosecutors are allowed to do when we have two conflicting sort of stories or testimony. And here that's exactly what we had. We had the witness saying that the defendant told her that he wasn't going to stop consistently to law enforcement, and that he said that he didn't see the trooper behind him until right before the stop. And so the prosecutor here was just asking the jury to consider the motive in the witness testifying consistently to law enforcement that he didn't see, or that he said he wasn't going to stop, and find that credible, and find the defendant's testimony that he did not see the trooper until right before the accident not credible. So if this court has no.
But did she go too far when she kind of asked the rhetorical question, you know, what motive is there to, you know, misrepresent here? And then goes one step further and answers that rhetorical question, says that I submit that there's no reason. Does that sound more like personal opinion?
And the state's view, no, because it was embedded in what the evidence was. So she was talking about her consistent testimony to the different law enforcement officers. So I think when you couch it within what motive does this witness has to tell, you know, trooper so-and-so this and lieutenant so-and-so this way after the fact, look at this consistent testimony and find that credible. So, and I wouldn't say that it's like the cases where the prosecutor or the state has specifically said, you know, she's telling the truth. Look, this witness is telling the truth, and some of those other blatant cases where this court has found error. I don't believe I have any further presentation for the court.
Questions? Thank you, counsel.
Unless this court has any questions, I'd waive rebuttal.
Thank you,
Thank
Mr.
you.
Levin. Thank you to both counsel for your arguments. We will take this matter under advisement.